The final matter to be argued before the court today is Marlene Matus versus the Jacts Group, LLC. Each party will have 15 minutes to present its arguments. The appellant may reserve up to 5 minutes for rebuttal. When you take the podium, if you wish to reserve rebuttal time, just let me know how much. I'll do my best to monitor that time for you. The arguments are being visually and audibly recorded to be posted online, so please keep your voices up and remain behind the podium. We have read your briefs and we're ready to proceed when you are.
Good morning. My name is Mark Stevenson. I represent the appellant Marlene Matus with respect to this matter. This is an appeal.
Do you want to reserve rebuttal time?
I do at least 5 minutes. Thank you for reminding me.
No problem.
This is an appeal of a judgment or judgments entered in favor of a possessor of real property and the owner of a building not far away from this courthouse in Montville Township. It is our position that the trial court erred when it instructed the jury that a customer who enters a premises and traverses an area, and then subsequent to that traverse of that area, traverses that area again and sustains an injury, that in that situation, that customer, which is my client, Marlene Matus, cannot recover pursuant to the open and obvious doctrine. It is our position that that is error because there was testimony, and it was uncontroverted, that the area where she fell did not comply with the Ohio Building Code, which had been adopted by the Board of County Commissioners of Medina County. The Board of Commissioners of Medina County not only adopted it, but they said it was to be specifically enforced. It's our position that that resolution is a law that promulgated a standard, a specific safety requirement for the public, and that specific safety requirement was violated because the area where Ms. Matus fell, it was a single riser stair. It did not have handrails, or at least, or even a single handrail that complied with the Ohio Basic Building Code. It's our position that the trial court erred when it instructed the jury in two ways. One, that if someone traverses the area, they cannot recover. But then the trial court did instruct the jury that if there's negligence per se, that they can. That's not a clear statement of the law. I submit to you that the open and obvious doctrine cannot be used to remove that resolution, that law, that the Ohio Building Code was to be complied with for the safety of the public. In other words, there was a judicial abrogation of the comparative negligence statute by giving the instruction on the open and obvious to such a degree that the jury was told they could not find in favor of Marlene Matus if it was open and obvious in a situation where there was negligence per se. With respect to, it's our position that the resolution by the county commissioners was a promulgation of a new law, and it was very specific. That new law applied to the unincorporated areas of Medina County, and it specifically said that the Ohio Basic Building Code was to be enforced and complied with. And the evidence before the trial court was that it had not been complied with.
Appellant seems to argue that there's not definitive evidence in the record anywhere that the Ohio Building Code had not been complied with. What's the response to that?
I think that Mr. Martin clearly testified that the Ohio Basic Building Code had not been complied with because there was not a railing that complied with the code that extended 12 inches, that went above the step and then extended beyond the step 12 inches, then went above the step, down the step, and to the floor and extended 12 inches out.
Was there testimony as to whether that particular step area in the restaurant qualified as a stairwell in architectural terms?
There was, in architectural terms.
I just said architectural terms because I believe he was an architect.
He was. The Ohio Basic Building Code defined a stair, a single stair, as a stairwell. And I believe that was cited in my brief as Ohio Building Code section 1002.1. The stair is defined as a change in elevation consisting of one or more risers. This was one riser.
Well, that's a stair.
It is a stair.
Stair versus stairwell. Is there a difference?
For purposes of railings, no. The Ohio Basic Building Code says that there can be a single stair, but there still has to be a code-compliant railing. And he testified that the railings that he observed and that were there on the date of the injury did not comply. I would submit to you that evidence was not controverted in any way. With respect to the first assignment of error, it's our position that the trial court abuses discretion when it would not allow Mr. Martin to opine with respect or on the issue of proximate cause. In other words, he was asked his opinion based upon probability or reasonable certainty as to the effect of the failure to comply with the Ohio Building Code at that single stair. And the trial court refused to allow him to testify because he was opining on an ultimate issue of fact for the jury to be decided. But Evidence Rule 704 clearly allows that. And he is the architect. He is the one who has the trained eye as to whether a single stair has been constructed or prepared in such a way that it complies with the Ohio Building Code and what the effects probably had with respect to that failure to comply. The trial court denied the motion for judgment notwithstanding the verdict with respect to the issue of negligence. It's our position that there was substantial, competent evidence in the record to support that there was negligence per se with respect to the area where that single stair was on the day that Ms. Matus fell when she stepped onto air, according to her testimony, and fell, injuring her ankle. There is no evidence. In fact, I don't believe, my recollection is that the appellee submitted no evidence with respect to any alleged compliance with the Ohio Building Code with respect to this specific area where Ms. Matus fell and was injured. If there is no evidence, if the evidence, putting aside credibility or the appearance of the witness, if there is competent, substantial evidence on only one side, And if after construing that evidence in a light most favorable to the opposing party, if the conclusion that can be reached is only in favor of the party that makes that motion, the motion should be granted. It doesn't mean that Ms. Matus is going to win her case. What it means is that the issue of negligence with respect to the appellees has been decided. The issue of proximate cause has not. Damages have not. And that's where the comparative negligence statute comes into play, which is why I submitted that when the trial court instructed on the open and obvious doctrine in a situation where there was negligence per se, there was a judicial abrogation of the comparative negligence statute, and it should not have been, the jury should not have been so instructed.
You're right, it's your 5 minutes. You can go on if you want, it's up to you.
I'm up to 5.
You're into your rebuttal time.
Thank you very much.
Okay.
Thank you, Your Honors. May it please the court and counsel, Kristen Campbell Trout for defendants Jacts Group and Golden Dawn. Keeping in the same order, I will try with the appellant's argument. The instructions that were given were absolutely proper in light of the evidence that was on the record. Despite the fact that plaintiff appellant uses the word uncontroverted several times, the evidence was absolutely, positively, in every way controverted that there was a violation of the building code. One of the plaintiff's own expert witnesses, the building code compliance officer for Medina County testified that the building plans were inspected before the building was built, testified that the building was inspected after it was built. Occupancy permits were given, and that one can assume based on all of that information that the plans were approved, the building was approved, and everything was code compliant. And that was notwithstanding stairs or stairwells or handrail. That building, as constructed, passed all of the code requirements, and an occupancy permit was given. That was plaintiff's witness. Plaintiff's second witness was Mr. Martin. Mr. Martin could not identify the difference between a stair and a stairwell. And at page 260 to 263 of the transcript, he admitted that handrails are only required in the instance of a stairwell. This is a stair. Whether it's an architectural term or a term of art or a statutorily defined term, this expert could not identify what those terms were. He admitted that with a single stair, you didn't have to have a handrail, and he could not identify this as a stair versus a stairwell, or identify this as a stairwell where handrails would be required.
Counsel, let me go back to your first point with the building department director or whoever it was. So he said that in order to be able to open, you'd have to get an occupancy permit.
Yes.
So everything should have been done according to code.
Yes.
Did he specifically opine that this specific rail or the step was according to code?
Mr. Randall testified that the building as constructed met all code requirements. As constructed, that single stair did not even have a handrail. The handrail was added later as an additional precaution because there was a patron that fell on the single stair. So there wasn't a requirement for a handrail in the first place. The restaurant went above and beyond by adding another safety feature, that being the handrail, in addition to the light strip across the nose of the stair, the different colors between the stair and the floor, the posted written signs that say caution, step down, and the hostess giving a verbal warning, watch your step. So this was just one more safety feature that was added after the fact. Mr. Martin could not testify that that handrail violated any specific code provision because, again, in order to meet the specific requirements that he was referring to, you had to prove that it was in reference to a stairwell. This was a stair. So all of the requirements that he was talking about did not even apply to this particular step.
When you say step, counsel, just so I'm clear, And I understand there are pictures in the record, but, so there's, you step from the tile up to the carpeted area, or do you step from the tile to a step to the carpeted area?
I don't have the pictures in front of me. I believe from memory, it's you step onto the step and then a carpeted area.
Okay. Thank you.
And then it is the step that has the light across the front. It wouldn't be the carpeted area. But again, I should have brought the pictures, and I'm sorry
No,
that I did
we'll
not do
take a look
that.
at them.
But in any event, the expert was allowed, even though he couldn't identify any of these terms, identify the specific code provisions, cite any specific code language. He couldn't do any of that, and the court still let him give his opinion that this handrail wasn't code compliant. He was able to give his opinion on pretty much everything that he wanted. The one thing that he was precluded in doing is saying that the effect or the proximate cause of a failure to have a code compliant handrail caused the injuries. He was not precluded from saying this because it was the ultimate issue in the case. The transcript is clear. The judge did not allow him to answer that question because in order to say that something was the proximate cause of an injury, you have to establish that something in the first place. The expert couldn't do it. All he could do is give his general opinion that this was not a code compliant handrail. But because he couldn't cite to a specific statute, he couldn't cite the language, he couldn't define this as a stairwell where these provisions applied, he hadn't laid the proper foundation to say that the effect of a failure to put a code compliant handrail in caused this particular injury. So it wasn't because it was the ultimate issue, it's because he didn't lay a proper foundation.
Well, it sounds to me like you're saying that he didn't establish the duty element of it in the breach.
Correct.
So I'm not sure why we even got the proximate cause, or what we're talking about proximate cause. I'm getting confused as to that, I'm sorry.
The reason that the expert was not allowed to testify about proximate cause is because he didn't establish the duty and breach of duty. So the court said you didn't lay the proper foundation. Because you didn't establish duty and breach of duty, you can't go to the step 3 proximate cause.
Did the court, as you can recall, actually say you didn't establish duty and breach, or did the court just say you haven't laid the foundation?
The court said you haven't laid the foundation.
Which can be completely different than breach and duty.
Well, in the context of a negligence action, there wouldn't be any other foundation other than laying the breach and the duty or the specific statutory violation.
Or just that the expert, for whatever reason, had not adequately testified as to his knowledge, as to any number of things that he could actually get to the proximate cause of the issue.
I think he failed in every respect because he couldn't identify the specific things that the court was asking him to identify. So let's...
Let me ask you a question about that. If the expert was going to opine because of these failures as he saw them, it created a hazardous condition, would you have seen a problem with that? I guess my question is, would that have been proximate cause? Or did proximate cause go a step further, causing her to be injured?
I think it would have been error to allow the expert to testify in that way because he hadn't established the proper foundation, and because if you don't establish duty and breach of duty, you don't get to proximate cause. I think at the end of the day, it wouldn't have made a difference. Even if this expert would have been allowed to say, in my opinion, this stairwell is a stairwell, you had to have code compliant handrails, and this handrail was not code compliant, they still would have just had his opinion that it's proximate cause. And if you look at all of the other evidence in the record, the jury was certainly free to find that that was not the case. The plaintiff testified that she was looking behind her talking to her friends. Both of her friends testified that the plaintiff was looking behind her talking to her friends. So even if you had established the duty and breach of duty through this expert, and even if you had taken his opinion into account that that was the proximate cause of the fall, the jury was still free to think, well, a woman who is not walking where she is going has already walked up this particular stairwell with no problem, and is simply not watching where she was going and looking behind her. How is she going to reach out and find the rail anyway? whether it's a 36-inch rail or a 31-inch or comes this far out from the rail or that far out, if she's not looking where she's going anyway, how is she going to reach out and grab the handrail? So the jury certainly had evidence in front of them. Even if the evidence had come from this expert, in my opinion, that's the proximate cause of the fall, that they didn't have to believe that evidence, that they could have looked at everything else going on and said, we don't think that that handrail was the proximate cause of the fall.
Given the jury instruction on open and obvious, could they have made that decision, that it was, didn't matter? Because they were told that if the individual transversed this open and obvious thing once, coming back, you can't claim that it was hazardous to her.
I don't think that the instruction is that clear that you cannot recover. I don't think that the instruction is clear as what the plaintiff is arguing, that it's a complete bar. I think if you look at the instructions as a whole, they gave the open and obvious instruction. They gave the instruction that it can't be dangerous on the way down if it's not dangerous on the way up. They gave the instruction on attendant circumstances, even though I'm not even sure that was argued. They said if there are attendant circumstances that you find, that might come into play. And then the jury got the instruction on negligence per se, which I don't even think was proper, because I don't think the plaintiff laid the proper foundation to even get that instruction. So the court really went out of its way to provide all of the information to the jury and let the jury take it from there and say, look, you have all of the information that you need to make your decision, go ahead and make it. So,
Except that, back to Judge Hensel's question, I don't even know how you would look at intended circumstances if you're instructed that if she was able to go up the steps, she can't claim that she was unable to go down the steps, it was dangerous. Or that wasn't open and obvious, I should say.
the open and obvious and the traversing front and back, those were separate instructions. So it was clearly set out that there were a number of different things that the jury could consider in deciding.
But how do you consider if the court has already told you that if they find that she already walked up the step, she can't claim it wasn't open and obvious when she came down the step?
Well, it said she can't claim that it was unreasonably dangerous. And then they went into the fact that a business owner is not liable for conditions which are open and obvious.
Right, but I mean, it all goes into the open and obvious.
I think it was an attempt to give the jury all of the information, open and obvious, traversing one way and then the other way, negligence per se, attendant circumstances. I mean, literally the jury had all of this information in front of it, so they weren't pigeonholed into this one little paragraph. They had all of these instructions in front of them when they made their decision.
So you're saying that, let's say, that when she was exiting, because I know what the facts are here, but let's just say hypothetically that when she was exiting, that a server had a cart in front of the step. And she, said, well, I really couldn't see where even the step was. I didn't, it wasn't open and obvious because I was, drawn into the cart and trying to go around it. Could the jury then have come back and said it was unreasonably dangerous?
I think in that limited circumstance, they could have done that because the condition wasn't the same coming up as it was coming down. But here, the plaintiff and her two friends both testified that it was the same coming up as it was coming down.
But my question is, and I didn't make it very clear, I apologize, but my question is, under the jury instructions as given by the court here, and the circumstances, the factual circumstances that I relayed to you, could they have come back then and said, that the Rockneys was negligent?
If you didn't also have the open and obvious instruction, maybe. But
that's what I'm trying to get at. I'm just not quite figuring it out. I'm sorry. I just am not trying to figure that out because obviously there's no point of an intended circumstance jury instruction if you've already been instructed that you can't claim unreasonably dangerous if you've already traversed the area once.
But I think that instruction is only appropriately given in the circumstances like we have here, when the situation doesn't change between the time she went up the step and the time she went down the step. I would argue, if I were the plaintiff, in the situation that you just argued, that you couldn't even give the RAFLO instruction in that case because the circumstances had changed in the meantime. So I don't even know that we would have been talking about that particular instruction. We would be focusing instead only on the open and obvious, and does the attendant circumstance make something that would otherwise be obvious, not obvious because the defendant blocked the plaintiff's view. I think this is a different circumstance, and in this case, because the circumstances hadn't changed, we have both the open and obvious and the fact that she had already crossed it once with no trouble and was coming down under the same conditions that she went up. And when we look at all of this, even if the plaintiff would get over the hurdle of the expert not establishing a breach of any particular code, and even if we, gave every instruction that he wanted, the only thing that we would be looking at is a violation of the Ohio Building Code. The Ohio Supreme Court has expressly stated that violation of the Ohio Building Code is not negligence per se, in Chambers and in Lang. And in fact, in Lang, they were dealing with the exact code provisions that are issued here. Steps and the risers going into and out of a public place, and handrails. And the Ohio Supreme Court said those particular issues, handrails and stairs, do not constitute negligence per se if you are only looking at a violation of the Ohio Building Code. Now, what the plaintiff wants to argue is because...
Your time's up.
May I finish this?
Go ahead and finish.
Thank you. What the plaintiff wants to do is elevate a violation of the building code into something that the Supreme Court said does not constitute negligence per se, simply because the county commissioners generally adopted the building code. If you were to say that that argument is correct, you would be completely eviscerating the Ohio Supreme Court's analysis in both Chambers and in Lang. Thank you.
Thank you.
With respect to the argument that the building plans have been inspected, and also the building had been inspected in December of 2008, before it opened. The testimony was uncontroverted again from Mr. Randall's that there had been no inspections of the property since December of 2008. There had been a fall, at least one, maybe more, up to 2010, and then the attempt at the handrails was installed, and those handrails stayed until the date of the fall by Ms. Matus, and they were not code compliant. Mr. Martin clearly testified that the area did not comply with the building code, and while he could not remember the specific subsections of the building code under the Ohio Administrative Code that set forth the standards that he testified about the substance of those sections and why there was a violation.
Counsel, I guess I'm confused because the appellee here is saying that that the restaurant installed the railing after the occupancy permit was given and it was found to be in compliance, that there was not even a need for a rail. So how could you be in violation of a building code that there's not even a need for one?
There was a need for one, and the inspection in 2008, when there were no railings.
So you do agree that there were no railings originally?
There were no railings when the building opened, and the attempt at the railings was not installed until after at least apparently one person fell, those railings are what did not comply with the building code on the day that Ms.
So you're saying if the building code doesn't require railings, but you install railings anyway, they have to be in compliance with the building code?
No, I'm saying the building code did require railings.
So the permit and the building department made an error originally in allowing it to go forward.
It's our position that the building did not comply with the code even though it had an occupancy permit.
That's what I'm saying.
Yes. Now, the open and obvious doctrine cannot abrogate negligence per se. In Langen and Chambers, there was no negligence per se. The specific adoption of the building code by the Board of County Commissioners, an elected body, to enforce the building code in non-commercial or in commercial properties in Medina County and the unincorporated areas, was a change in the law. It was a new law for the protection of the public. And that law was violated because there were not code-compliant railings at the area where Ms. Matus fell. Thank you.
All right. Thank you both for your arguments. We will take the matter under advisement, issue a written decision in due course. It'll be mailed to both sides as well as posted on our website and on the Supreme Court's website.